Hi everybody, my name is Pat Hogarty and welcome back to Sacramento City College. I'm a professor of real estate. And again, this is a continuation of our series on where we're bringing in guest lecturers, or if you want to call them guest lecturers, guest speakers, but in reality guest experts on specific topical areas. We've been talking to a gentleman by the name of Dave Tanner, who I'll quickly introduce again, and we're getting to the third show now, if we want to call it a show or a lecture. And this one is going to have to do with what do we do when we have some kind of a dispute between the buyer and the seller. You know, where the buyer thought that the seller was going to be providing something, maybe you know, that the house was going to be in a certain condition, you know, that a window was going to be replaced, or carpeting was going to be done, or it wasn't, whatever, and they find out that's not true. How do they resolve that dispute? And so what we're going to be talking about is what we refer to negotiations, which is going to be where we try to resolve this, if you will, like an adult, hopefully. And then we're going to be talking about something called mediation, and we're going to get some clarity on what mediation is. And then we're going to be talking about arbitration, which can be, if you will, a fairly complex subject. And so what I want to do is I want to introduce again Dave Tanner, who's the CEO for the Sacramento Association of Realtors. And again, as I mentioned before, Dave has had many, many years of experience as both an attorney and as a real estate broker dealing with contracts, and has taught real estate agents how to correctly fill these, as we're finding out as you watch these shows, all these contracts that are required, which can end up being a stack of them, and how to correctly fill them out so that we, in the long run, we keep ourselves out of trouble. And so what I want to do is first start talking about where we have a dispute. And the dispute could be between the buyer and the seller for some problem, or it could be, we could also talk about if we have a dispute between ourselves and the real estate agent. And so the typical thing that I would like to talk about first is if we try to go in and resolve this as an adult, and that would be negotiations. And so could you tell us a little bit about that?
Yeah, well, what we always encourage, most of these disputes arise after close of escrow, although some arise first. But first, they're probably easier to resolve because you still have a little bit of leverage, because you still have an open transaction and the parties are trying to make it happen. After you close escrow, the parties have an easier time digging themselves into the position that they believe in, because escrow is already closed. They have nothing to lose at that point. Generally what happens is the buyer alleges that I didn't get what I contracted to receive, or you didn't disclose something to me that you were required to disclose to me. The seller's position is usually, I gave you more than what I was required to give you, and I told you everything I knew about the property. Okay. So then you end up with a dispute. And what we always encourage is that the parties try and resolve the dispute on their own if they can, because it's certainly easier if they try and resolve it on their own, with or without the assistance of the brokers. Okay. Usually the brokers can be a help in that, as long as the brokers are acting professionally. Sometimes the brokers get entrenched in the position of their client, which doesn't really benefit anything. The broker really should be, although they're an advocate for their client, they need to provide some balance, because if all they're going to do is just parrot what the client is telling them, then they don't really need the broker to be involved in the transaction. Right. Sometimes it is, well, yes, I understand that that's what you're upset about, and that maybe you really should have gotten that, but escrow's closed now, and why don't we look at this as maybe an alternative way of resolving it? And maybe they can be able to work out something that way. If it doesn't look like that's what's happening, when I was managing offices and talking to agents, often we looked at it, and if it was something that could be resolved for nominal amount of money. Sometimes I'd encourage the agent just to take care of it, because the hours that you spend trying to resolve a dispute between the parties, if you can pay for somebody to come in and shampoo the carpets and have the problem go away, that may be the best thing that you can do, because you get it off of your plate, it's not a problem anymore, and also you've made your client happy because you've stepped up and solved their problem for them. So sometimes that's the easiest way to resolve the disputes.
Have you found, just out of curiosity, in all your years of practice, have you found that there are certain, let's say, buyers who would bring the issue up that are just sort of drive you crazy because they find all kinds of things wrong after they buy the property?
Some buyers expect that they are going to buy something that does not exist, which is the perfect house.
Okay.
Every house is going to have something wrong with it. And the seller's duty to disclose problems with the property. We talked before in an earlier class that we did about the transfer disclosure statement, the seller's obligation to fill out the transfer disclosure statement on 1 to 4 unit residential properties. That asks very specific questions. It doesn't cover everything that could be an issue with the house. But then there's a separate law that says the seller must disclose anything that materially affects the value or desirability of the property. But that's kind of, the beauty is in the eye of the beholder. What significantly affects the value, desirability of the property to me may be something that would not at all fall into that classification for you. And particularly if you've been a seller living in the property for 10 years and that issue has been there for 10 years and you've become quite comfortable with it, you probably don't even think about that as being something that affects the value or desirability of the property.
Right.
When the buyer moves in and they've never seen it before, they may say, oh my God, what happened to me?
Right.
And it becomes a material issue to them. So it's not really clear where that line is about what must be disclosed or does not need to be disclosed.
Okay.
Generally, our advice to the clients is if you think about whether you should disclose it or not, disclose it.
Disclose whatever it happens to be, yeah. And do you find that trying to stop things from happening after the escrow closes, a lot of times we have what we call a final walkthrough inspection. Does that help at all, or is that just something that people feel obligated to do and really don't pay much attention to it, or what?
Usually that helps, but the thing to make that really work is to make sure that when your client is when your buyer client is doing their final walkthrough, make sure you're there with them and make sure that they are looking at things. Because sometimes they just go in there and they look at it, oh yeah, that view is as beautiful as I thought it was going to be, and they aren't really looking at the house.
Right.
And then 5 days later they've closed escrow and then they get ready to move in and they go back and start looking at the house and say, gee, there's only one electrical outlet in this room. I thought there were 5, where am I going to put my TV?
Right.
So make sure that they're focusing on the house rather than the beautiful view when they're doing their final walkthrough.
Okay. So anyway, what you're really saying is that if we do have a problem of something, we try to get the thing negotiated, we try to get it resolved, and the fact of it's happening during the escrow, there's a little bit of leverage on both sides. In other words, the buyer could maybe say, well, unless you fix this thing, I'm not going to buy it. Or, the seller can say, I've had it, I've done everything you wanted me to do. I am not going to put, I'm not going to wax the floors, or I'm not going to, in other words, we can resolve that. But then we also have the thing that happens after escrow where everybody goes, wow, we're all finished, we're all done. And then that's a totally different issue.
Right.
That. Right. Okay. Now, the next thing that gets to be confusing is the fact that in the bottom of both the purchase agreement, as you've mentioned before, and the listing agreement is something called a mediation and arbitration clause. So can you tell us first, let's try to get this cleared up about what mediation is, what it really means, when do we agree to it, just kind of tell us all about it.
Okay, well, mediation is the concept of using a third party to try and help the two parties that have the disagreement to reach a resolution that each of them can be happy with. It's an entirely voluntary process from the standpoint of whether they reach a resolution or not. Now, having said it's entirely voluntary, let me go back and say that in the purchase agreement, and in the listing agreement, the mediation clause is mandatory. It says that the parties must mediate. And that's standard in the contract. So when they enter into the listing agreement or the purchase agreement, they've agreed to be bound by mediation unless they've gone through and lined it out. In an earlier segment, we talked about lining things out, and you want to make sure you talk to an attorney before you do that.
So wait a minute, let me stop you there. If the client does line first of all, I think what we need to make clear is that as a real estate agent, we are not creating. We're using an existing contract that's been created by the California Association of Realtors by attorneys. We're filling out a form, but the contract is there, and when a client starts to strike out paragraphs and things like that, what you're saying is they really need to be talking to their attorney.
That's correct.
Okay, we want to make sure we're clear. Striking it out and initialing it is not the way to go.
Right.
Okay, so I'm sorry, go ahead.
So you have the mediation obligation in the contract. So if a dispute arises, then the parties have an obligation to mediate, to use a third-party mediator to try and resolve it.
And who pays for that?
Generally, it's shared between the parties.
Okay.
In the residential purchase agreement, there's an incentive in there that says that the parties must mediate. And if they do not mediate and they go directly to litigation, that they can lose their right to recover attorney's fees. Because in the residential purchase agreement and in the listing agreement, there's a provision that says that if there's a dispute between the parties, the prevailing party is entitled to recover their reasonable attorney's fees. But the mediation clause says if you refuse to mediate, then you lose your right to try and recover attorney's fees in litigation. So it's an incentive there to keep people from skipping mediation.
Okay.
I think mediation is probably the best way to go. My experience is that most cases can get resolved by mediation as long as the parties really want to resolve it. As long as they're really looking for a legitimate way to get a problem solved, a good trained mediator can resolve most issues.
Okay. I know we're going to talk about this in a later segment, but what would be the, I guess, first of all, how would the people even find a mediator? Okay. And second of all, what would the cost be? What would the people expect to pay? What would be the expectation of fees?
Yeah, it just depends on where you go. I mean, for finding a mediator, you can certainly look in the yellow pages. There's people now that have developed practices that's all they do is mediate.
Okay.
There are quite a few attorneys that I know that have developed a mediation practice, that they have expertise in an area such as real estate, and they will do mediations in that area because they've got all this background and knowledge, and they can really help people mediate. When I do mediations, one of the things that I find is that the parties come in and they both believe 100% that they are right.
Oh.
That's why they're there. And so a good mediator can sit down separately with the parties and point out to them that I understand that you think that you're entirely right, but here's the area where you have some weaknesses. And if you end up at arbitration or in court, that this is what you're going to have to prove, and do you really think that you can prove that?
Right.
And if they start thinking about, well, maybe I can't really prove my case, then they start thinking about maybe I need to try and resolve the case.
So you're saying that the mediator actually is providing not only the mediation service, but they're actually providing some advice to the client to really do some soul searching to say, are you realistically sure that you really want to do this? And this is what you would really need to, this is what it would cost and what you would need to do to, to go to court.
Yes. The other thing that I point out to them, in addition to the issues of being able to prove their case, and also, as you mentioned, the cost of going to court, the other thing is that when you're in mediation, you can resolve the case almost any way that you want to. You can be very inventive about how to resolve it. You can split the potential pot of costs between the parties however you want to do it. If you go to arbitration or court, there's generally going to be one winner and one loser. And when I talk with people when we're doing mediations about, you realize if you don't resolve this at mediation, you move forward to arbitration. Somebody's probably going to end up with a win, and somebody's going to end up with a loss. But today you can reach a compromise resolution that you can live with, and if the other party can live with it also, maybe that's better than betting that you're going to prevail when you move on to the next step. And I find that most of the people have thought, yeah, this is my last time to really control the outcome. Maybe that's what I want to do.
Now, does this mediator, do they, I think they call it in the legal terms discovery, where they find all the documents and the stuff. Do they actually collect all of the forms and agreements and escrow instructions and disclosures before they ever meet the clients and go over that, or and is that called discovery, by the way?
Well, it can be, but mediation is generally a much more informal process.
Okay.
And when I'm doing mediation, generally I don't want them to do that, because I don't want them to dig themselves into a position that then they're going to try and defend.
Okay.
I would rather just have them come in and talk about what they perceive as what they should be entitled to and what they did not get.
Okay. Okay. Now, so the mediation, and I did want to ask you, we skipped this. What does this cost? I mean, is this like $100 an hour, $200 an hour? Is there a fixed rate or a fixed fee for it, and how long would one be expected to be in? Is this something that lasts all day, or so what's the fee and how long does it last?
It just depends on where you go, and we're going to talk in a future segment about doing mediation through the association and arbitration through the association. But if you go out on the market for mediation, it depends on where you go, but you probably should expect to pay a minimum of about $225 an hour.
$225.
Maybe more, and a lot of them have a 3-hour minimum.
Okay.
But then most of them, their contract says that is split between the two parties. Okay. So it can end up, if you're at $225 an hour, then you'd be each party paying $375 to come in for a 3-hour mediation. And if parties are reasonable and really want a solution and they have a good trained mediator, 3 hours should be more than you need to reach an agreement.
Now, is there, when the mediation is over, when it's done, is there a document, a contract that is signed or something that says, here is our formal agreement? And I guess the question is, can the settlement be verbal, or does it have to be in writing? And if it is in writing, is there a certain document that has to be signed by both parties, and does it have to be recorded or notarized, or what do you do with that?
Well, you certainly could have a verbal resolution at mediation, but no professional trained mediator would ever resolve it that way. Okay. I mean, the parties can do it on their own, reach an agreement verbally. But if you go to a trained mediator to do it, it's going to be prepared in the form of a written agreement which all the parties sign, and then that becomes a new contract between the parties.
Okay.
And so now if they end up with one party not performing, they don't have to go back to the purchase agreement and bring up the issues that got to it. They just go back and say, here's our mediation agreement. We're asking the court to enforce this.
Okay.
And courts will generally do that as long as there was a due process involved and nobody can show that they were taken advantage of.
Okay. That
the mediator was not the brother-in-law of the buyer.
Okay. So in other words, the buyer would sign it. I guess I would sign it, my wife would sign it, the other party, if they were married, they would sign it, and then I guess the mediator signs it, and then is it like notarized, the signatures and stuff like that, or?
They just give a copy to each of the parties, and then it's up to the parties to enforce it if the other party does not
Okay, so
comply.
if they agree to a certain amount of money, like $10,000 to fix the broken fence or something like that, and the seller doesn't provide the $10,000, then their actions, then they would go to court with that, right?
Right.
And then the court would, you'd introduce that document and say, Judge, please make this guy do this. And then they would...
They'd say, here's our mediation agreement. It said that they were going to pay me $10,000 within 60 days. It has now been 90 days. They haven't paid me yet. And we want the court to issue an order that they owe me this $10,000.
Okay.
And the courts will generally do that.
And that order would be what? I mean, would they, can they force them then to garnish wages and take cars and airplanes and motorcycles, or?
Once you've made that an order of the court, then all of the efforts to collect any court judgment would apply. So you can, yes, garnish wages,
Okay,
seize assets, whatever you can do.
all right. Okay, so let's move on now to arbitration. And this is the one that, let's just talk about it. You mentioned before that it's both in the listing agreement and in the purchase offer agreement. It's down the bottom, I think, on the last page of the contract, if memory serves me correctly, but I could be wrong. I don't remember all these things clearly. But the arbitration agreement, so if you could talk a little bit about are the people absolutely required to sign this and approve this arbitration process or not? What happens, and how do they, if they are agreeing to, what do they have to sign, and how does that work? You know, if you could fill us in on that.
Okay, well, the arbitration clause in the listing agreement and the purchase agreement, both of them specify that if they agree to the arbitration clause, then they're agreeing to binding arbitration.
Okay.
Which means that they take it to an arbitrator, the arbitrator issues the decision, that's binding. There's no appeal to court, there's no other place to go. The decision of that arbitrator is the final resolution of the dispute. So California law says that to have that arbitration provision in a contract, the parties must separately initial that provision. So in both the listing agreement, there's a place for the broker and the seller to initial that provision. In the purchase agreement, because the purchase agreement is only a contract between the buyer and seller, that paragraph has a place for both the buyers and the sellers to initial the contract. All of them must initial or it's not binding.
Now, you said on the listing agreement, if memory serves me correctly, you said that the broker has to initial it because the agreement is between the broker and the seller of the property.
That's correct.
And, okay, and so then on the buyer's side, this broker doesn't sign it, but the buyer signs it, right? Have I got all this thing correct? Initials, not correct. Initial, yeah.
On the purchase agreement, it would be the buyer and seller
Okay.
that would initial it. Now, there's another concept we haven't talked about, but there are contracts where brokers have a written agreement with the buyer for the broker to represent the buyer. And if they do a buyer representation agreement, then the arbitration clause in that contract would be initialed by the buyer and the broker because that contract is between those parties.
And that would be where I would contract with a real estate agent and say to the agent, please, I want your help and I want you to represent my interests and I want you to find me a house to buy.
That's correct.
And that would be almost analogous to the listing agreement where I'm employing the broker or well, actually it's always the brokerage, but I'm employing the brokerage in order to sell the house. In this case, I would, if I was using the buyer if I was using the agents exclusively to help me buy a house, then that would be between the buyer and myself.
That's correct.
Okay, okay. So now we've got this arbitration that we've agreed to. What are the steps that we go through then to get this resolved?
Well, you would file for arbitration, and depending upon where you file,
Is that in a court that we file or what?
you would file with arbitration with an arbitrator. There are several places you can go for arbitration. One of them is that there's a group called JAMS, J-A-M-S, that is active in Sacramento area, and they're retired judges, and you can hire them to arbitrate the dispute. There's also other arbitration associations you can go to, such as the American Arbitration Association, which establishes rules for arbitrations. And then you can also go just to individual arbitrators. A lot of attorneys now have started doing arbitrations as a sole arbitrator. You can hire them to arbitrate the dispute.
Now, what does that cost me?
Again, it's going to vary. It depends upon JAMS, for instance. I think that a lot of the retired judges that work for JAMS are charging somewhere in the area of $500 to $750 an hour.
Wow.
So it can be quite pricey to go to arbitration. So it's another incentive for resolving things at mediation where you have more control over it because it's also more cost effective.
So, I mean, I guess if I'm upset about the fact that the carpets weren't shampooed and it's going to cost, me to hire a guy to shampoo the carpets, and it's going to cost, $100 to $200, it doesn't make any sense. So what we're talking about is something that's a large dollar value thing, like, I guess, the seller didn't disclose to me the fact that the roof leaked like a sieve in the wintertime, when I bought it in the summertime. That would be something that I would maybe go to, because maybe that the roof would cost me $15,000 or $20,000 to replace, I guess.
That's correct. Now, back earlier we were talking about mediation being mandatory in the contract unless it's lined out, and arbitration being mandatory if it's initialed. But there's also another subparagraph in the bottom that establishes some exclusions from the duty to mediate or arbitrate. And one of those exclusions is if the amount in dispute is within the jurisdiction of small claims court, which is now $10,000 if you don't go to small claims court more than twice a year. So for most of those small disputes, the parties could elect to bypass mediation and arbitration altogether and go directly to small claims court. So in the dispute where you had one over shampooing the carpet, small claims court's probably the better way to go. Because you can go in there for about $50 and get a court hearing in about 30 days in Sacramento County.
And the limit is $10,000?
The limit is $10,000.
At least today in 2012. Okay.
For natural persons. Corporations have a lower limit, so corporations can't run around suing people and take advantage of that. They have a $5,000 limit.
Okay.
But natural persons that don't use small claims court more than twice a year can sue for up to $10,000 in small claims court. Go to small claims court, there's no attorneys allowed. The parties just go in, tell their story. You have an attorney that volunteers that sits as a judge pro tem in small claims court. Generally, from the time you file it, you'll be in court in about 30 to 45 days. You'll go in, you'll state your case. They'll take it under submission, and about a week later, you'll get the decision in the mail.
Okay.
So it's a very inexpensive and fast way to dispute small claims.
Well, Dave, I'm glad you mentioned that, because that was one thing that wasn't on my list to talk about, and we're just almost out of time. We have about 15, 20 seconds left, and I want to thank you again for taking the time to go over this. This is something that's really important, and I think it is because of the fact that we have to explain this, or our real estate agents and brokers have to explain this to their clients so that they realistically understand what's going on. And I want to thank you very much for coming here.
My pleasure to be here. Thank you.